Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything.
Hello, lovely people. Another Saturday is here with us, and we have the privilege and the honor to come your way again on the Community and the Law, brought to you by BWF Solicitors. And this afternoon, we're looking at your British children born abroad. What kind of rights do they have? Do they have right of abode? The emphatic answer is yes. How do we find out? How do we know? And what do we do about that? My name is Oreku Frimpong. Good afternoon and welcome to the event. The Community and the Law is live.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we are live with you on YouTube and Facebook, both at BWF Solicitors and, of course, on BWTV. My name is Uriku Owusu-Frimpong. Good afternoon once again. Another Saturday is here with us, and we have the honor and the privilege to come your way with the community and the law. This afternoon, by courtesy of BWF Solicitors, we bring you another very interesting discussion. Now, we're talking about your British children that are born outside of the UK. Did you know that they have the right of abode? Right of abode, what is that? We shall be unpicking that, and also to let you know what to do about the right of abode of your child when they are born outside of the UK or abroad. We have as a resource person and guest lawyer Charles Asma from BWF Solicitors, who is going to take us through all that. I will be introducing him later on in the program, but before then, let's catch up with some updates for the community. We're looking at a client review. People have visited VWF Solicitors, they've used their services, and they're very excited and happy about that. Now, let's look at this. We will be delighted to recommend BWF Solicitors to my friends, family, and anyone who requires really their services. I brought my partner's immigration issue to BWF Solicitors, and this was handled by lawyer Charles Asma. Well, lawyer Charles Asma happens to be a resource person this afternoon. He's excellent in handling the partner's immigration issue, and it's brought happiness to my home, and her immigration status has been granted. I will recommend, or we will recommend, lawyer Charles Asma to anyone, any day, anytime. This is from Robert Amponsa, who is so happy to do this because he's found satisfaction when he brought his issue to BWF solicitors. So to this family and to everybody else, what we want to say, trust BWF solicitors. You can find them on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. Postcode is N154NP. If you go by public transport, get on the Victoria line, get off at Seven Sisters, use exit number 2, and that will take you to the frontage of Anna House. BWF Solicitors is located on the fourth floor. So BWF Solicitors, salutation from this wonderful family, and keep doing what you're doing. Lawyer Charles Asma will be on pretty soon, so you know who we are talking about. But for our nugget this week, we're talking about mesh order. What is that? What is a mesh order? That's the obvious question you will be asking. Now, dividing matrimonial assets after divorce is difficult at the best of times. The courts really have found a way of postponing the division of properties within a marital relationship to a later date when there is not enough to go around. A mesh order, as we have mentioned here, allows for a delay to the sale of a property for a finite period of time or until a specified event occurs in relation to the children of a family. That will enable one party and children to continue to live there. So Mesher and versus Mesher 1980 case as what we are looking at as our nugget. I will be getting Lawyer Charles Asma to look at that, but there are a few things that the community needs to take note of. So let's pick those and we'll come back to this measure order and we look about. Employers, so to speak, must give back tips to staff. Okay, imagine this. You go to a restaurant, an eating place, a place of entertainment, and people come to serve you. And when they have served you, now you give tips to them. How is it handled? Is it given to the employees that came to serve you, or what happens? I must confess, I normally don't know what happens to that, so I refuse to give tips. But then, this is the law about it. Now let's look at it in details and closer. The new rules, if we can have it bigger on the screen for everybody to read out. We're talking about the new rules on tips have come into force. And if I'm right, it started on the 1st of October this year. And it says any business that received tips, gratuities, or service charges must now, 1, pass on all tips and service charges to workers without deductions, except in very limited situations, such as deduction of income tax. The other bit is you can't make any deductions by way of bank, payroll, administrative charges, or anything like that. Tips must also be paid to agency workers working in the business. Then the third point is you must ensure that tips are distributed in a fair and transparent manner, which involves you taking record and control or exerting significant influence over how they are distributed. The employer must have a written policy available to staff that explains how you will distribute tips to your workforce and complies with the new law and code of practice. Then finally, we are saying that employers must maintain detailed records of all qualifying tips, etc., paid over a 3-year period, and 6, respond to any requests made by your staff about the amounts of tips received and the portion allocated to them. So I know like Charles Asma will be explaining that in detail, but tell you what, when you go to a restaurant, a place where you are charged service charge, I have a belief that they don't give it to them, or there are some deductions and all the other bits. So we have the law coming in to really regulate this, and for that reason, I would want you, wherever you work and there are tips, go for some details, because they may be cheating you one way or the other. Another bit for the community, let's look at duty on employers to take reasonable steps to prevent the sexual harassment of their employees. Now, these things I know are happening to so many people. So let's look at what the law is saying about that. Coming into effect from the 26th of October, employers have a new duty to take steps to prevent sexual harassment by their employees in the course of their duties. Employers are vicariously liable if their employees are found guilty of sexual harassment unless they can show that they have taken all reasonable steps to prevent the harassment. This is a very high bar. The new duty departs from the current legal position by introducing a mandatory and positive obligation for employers to take reasonable steps to prevent sexual harassment. Well, I'm just a host. The lawyer is here, the specialist is here, and he's got the legal brain to explain that. So, with that, I introduce our resource person and guest this afternoon from the stables of BWF Solicitors. I have a friend, a brother, and our teacher, lawyer Charles Asma. Good afternoon, sir.
Good afternoon, Bragoku.
How are you doing?
Very well. How are you?
Well, I'm fine. We're so happy to be coming the way of our viewers, listeners, and clients again this Saturday afternoon to help empower them by way of knowledge and, of course, as far as the law is concerned. We have got updates, but first of all, let me go to the very beginning where somebody has come to BWF Solicitors. You have served the person so very well. Himself and the family are so excited and happy about that, and they are saying thank you. Thank you, Charles Osman.
Thank you. It's always a pleasure to add to the smiles and laughter of clients and the many people within the community whom we serve. And therefore, this is what we stand for, making expectations real.
Right. And thank you very much. Of course, beyond that, you spend your Saturday afternoon with us to help educate us. So we move on beyond that. And Oliver, we always ask for more. When we say measure order, what are we talking about?
Thank you very much. So, measure order is an order from the court, and it's an old order which is still valid. It's a case of measure and measure. So you can see that these are Mr. and Mrs. or family members, one taking the other to court. And the outcome is that the court has a right or power to make an order in the interest of the family when it comes to post-divorce settlement issues. So after divorce, there should be settlement of the financial matters, money, assets, and anything else that the family held together. The paramount interest is the children in any decision that will be made. So if we decide that we are selling the property, the question will be, where would the children fit in this scenario of selling the property? If we have only one property and we sell it, what happens to the children? The other part, the adult parties may not be interested in each other, but the children's interest should be supreme or paramount. And so there are instances where the court will look at the circumstance and say that this is not the right time to, for example, sell the property, because if you sell the property to share even the money or whatever there is or the proceeds, the children will be caught in the middle and they will be at the losing end. And so court has the power to make an order. It says a measure order allows for a delay. So it's not a case that we are not settling, but we are postponing the settlement, especially where we need to sell the family matrimonial home or the family property. If we have to sell it, where will the children be renting? Are we going to buy another property for the children to live and all that? And so the court may make an order to delay a sale of the assets involved in the interest of the children. And it says that This will enable one party and the children to continue living there until such a time that it is appropriate or necessary to sell their property. So that at least that time, the children would have moved on, the children would have been okay, a new property would have been found which would be conducive or adequate for the children's needs and so on and so forth. So it's simply the court saying that, yes, divorce is over, proceedings are completed. The property that are in question or is in question need to be considered. And if any of you wishes for the property to be sold so that money is shared and settlement is completed, we cannot sell that property because the needs of the children must come before any or all other needs.
Okay, Lawyer, let me look at the scenario where, for instance, one of the partners or ex-partners, so to speak, marries, and the children in there are still children. They are below 18 or thereabout. So in that situation, what happens? Can they sell?
Even the children
So,
are
for
below.
instance, when the divorce is over, the man marries again. Can they sell? Because the man probably may move out of that property.
Where, well, if there are children involved, the children are likely to be living with the woman, right? Are likely to be living with the
Mhm.
woman. And so on that basis, we cannot talk about the woman per se. We'll be not talking about the man, we'll be talking about the woman, so to speak. So the
Mhm.
interest of the children is what the court will consider.
Okay, then in this situation, I am assuming that if the children get to 18 and above, or probably by the age of 21, that will be the point in time where the court could say, well, they are not children anymore, they can move on. So then at that point, you can sell the property. Would that be correct?
So the court will have to look at appropriate time. An appropriate time will be to look at the children, how old they are, when are they likely to be old enough, if there's going to be new property in the future, when is it likely to be for the children, and so on and so forth. And once all these are factored into the conversation or discussion, the court will then make appropriate order for the needs of the children.
So this measure order, there would be one way or the other, if for the ordinary person, an injunction on the sale of the property until such time that circumstances have changed. Does it mean that at the time of the ruling, the lawyer, or the judge, so to speak, sorry, would say that I'm giving you 10 years because the children would have been 21 years by then. So after 10 years, come back for another order. Is that what happens?
So the whole thing is, when should there be what we call clean break? So a
Mhm.
clean break is where we settle all the matters. So we see each other as ordinary friend or members of the, or let's say as friends, as opposed to family
Mhm.
members, because there's a clean break. But clean break where there are, it works better when where there's no child or children, but where there are children involved in this conversation, clean break will be subject to other needs of the children. And so, if the children's needs will be affected when there is going to be a complete clean break, then the court will delay that complete settlement so that
Mhm.
they will look at when. As to when that will happen, all this will be factored in. The court consider or will also have the power within the order to put in certain conditions that if this happens, we'll do this.
Mhm.
This must happen. So the court will put all this together, but the power resides with the court. The most important thing is that where it is difficult to sell the property at early stage because the children will be affected, the court has the power to delay that process. And that order is called measure order, from the case of measure and measure.
Well, thank you for that. I know viewers may be having further questions on that. You can send that to us via text 07399 208468, 07399208468, either via text or WhatsApp message, and we'll send that over to Lawyer Charles Asma to help us look at that. Now, there were two other updates that we mentioned earlier on, Lawyer Asma. The first one is about the new duty on employers to. Oh, okay, okay. Let's look at this first. Giving back tips to staff. I have said, and I think earlier on I mentioned and alluded to it, that when I go to a restaurant, I go to a public place of entertainment, and they charge me service charge, I don't pay because I am of the opinion they don't give it to the workers that really came to serve me. What is the new order saying? Is it going to help me understand the situation so I can start paying service charge and tips?
Right. I mean, it is not because the court want or the parliament want people to be paying more tips. It's to ensure that the tips go to the people who are the beneficiaries of those tips, and at the same time, there are no restrictions to those tips.
Mhm.
So let's unpack this in a minute. So the first thing is there are tips that are regularized. If I say regularized, they are factored into the cost of the service. So you go to most restaurants after eating, they give you a bill and tip is already calculated 5%, 10%. So it's not like I will pay or not. It's already in there. So that
Mhm.
money goes through the system, and so the employer or the owner, yeah, so employer in this case is aware how much tips have been received in the day or in a month. So most employers will put all together and add it to the employee's salary. But because to them they are working, and therefore the tip shouldn't be extra income, they will deduct the tip from the usual salary. For example, you are
Mhm.
supposed to be paid £900, let's say £1,000, and you have a tip of 100. Instead of employer giving you 1,100, the employer is giving you 1,000 and saying that the tip is not for you anyway. Your 1,000 is what has been given to you. Then that's not fair. That means the tip that the customer or the client is giving to the worker has been rather has gone rather to the employer. The tip is not for the employer, it's for the employee. So how do you ensure
Mhm.
that the money goes to the employee? And before the law came, there had been instances where the employers would hold the tip from the employee, or say that we are deducting £100 from your salary because you have a tip of 100. All these things are not in the employee's favor. However, because the employer is the one handling it, and there's no law to say you can't do it, they were doing it. And now what the law is saying is that one, you have to put all the tips together. Two, you have to make sure that you give it to the employees or the staff. Three, you have to make sure that everybody who must receive the tip gets the tip. So you are not going to discriminate in the sharing of those tips. And four, you have to ensure that there's no tax or any other bit that you would decide to deduct, unless the law requires that it is considered as part of your earnings and tax deducted. You cannot take anything out. You give it to them wholly and absolutely. And because of this law, employers cannot have a leeway. How much do we give and how much do we keep? Imagine there is for the month, the company has received tips of, let's say, £5,000. That is tempting, isn't it?
Mhm.
And so they can choose to keep, let's say, half of it and give half to the employees. The law is saying that you can't do that. You have to give them everything, and you have to make sure that you have a way of recording it and you have a way of reporting it. And it is obvious that everybody who has to benefit from the tips benefited from it. And it has to be fairly shared or distributed.
Well, somebody just texted me to say that service charge is not compulsory. Is that correct?
Well, of course, it is not. There's no law that says that we should pay service charge, but it's become convention or conventional, and therefore, when you go to a restaurant and they give you a bill, you don't check to say that, oh, why have you added service charge of 10%? So I'm paying less of that. We don't do that, do we?
Well, some people do. I've done it before.
Oh, for example, they gave you the bill, and the bill included a service charge, and you paid less
Yes,
of
and I asked them to take the service charge of the they did.
it, which is fine because there's no law. However, those people that do not ask for the service charge to be removed and they go ahead to pay, who benefits from that money? That's the point. So
That's the point. Okay.
to the questioner is that yes, it's not compulsory to pay service charge, but if you choose to pay, it must go to the right people.
And those conditions spelt in there, I think about six of them, spelt in there, must be followed. It's not subject to task and all the other bits. Um, I think if you have employed people, especially those who have employed people in your restaurants and bars, you must adhere to this. If you want further details, as I have said already, you can contact BWF Solicitors. They will help you, educate you on that. You can send a text on 0739920848 and ask your question or send in your comments. You can leave them in the comment section down below on both Facebook and YouTube. Um, Yes, let's move on to the other one, and it's about sexual harassment of employees. Enlighten us on this one as well, lawyer.
So we know that within the Sexual Offences Act or Offences Against the Person Act, we have provisions that deals with sexual harassment. Now, the employer can say that, well, I didn't cause it, and therefore whoever caused it will deal with it. But the question now will be that if it happened within the jurisdiction or the parameters of the employer's outfit or setting, could the employer have avoided it or been able to? And therefore, there's now a duty on the employers. That's what we call vicarious liability. So the employer will be
Mhm.
vicariously liable because the offense would have been committed or might have been committed by an employee of that employer, especially if it happened in the setting. This is different from somebody doing whatever they do outside of work. If it is outside the work and outside the hours of the work, then that will not be employer's responsibility. But insofar as it's within the confines of the employment hours and also the vicinity, the employer will have a duty to ensure that one, it shouldn't happen. And if it does happen, it will have a responsibility to respond to.
It would be a difficult area to enter, but let me find out. At the workplace, what would normally constitute sexual harassment?
Well, harassment is a concept that can be broadly interpreted, but anything that makes the person uncomfortable and it is within sexual context, that would be sexual harassment. So if you, for example, remember sexual harassment include touch, physical touch.
Hmm.
It could even be non-verbal communication that could be misconstrued to be of sexual nature or with sexual connotation. And therefore, anything that makes somebody unhappy or the other party unhappy and it is of sexual nature could be considered to be sexual harassment. We can have a range of lists or examples, and those will not be absolute or exhaustive, and therefore it depends. If a matter goes to court on that basis, it will be considered to be whether a reasonable person will see this to be sexual harassment.
So, is the law saying that is the responsibility of the employer to make every employee aware that certain acts, behaviors, and omissions maybe could be seen as sexual harassment, so they should take note of.
So, of course, employers educate their employees regarding all aspects of the laws. And if I say all aspects of the laws, that deals with the job they are carrying out. So, question would be, how can the employer absorb itself or him or herself from that liability? Yours is to make
Mhm.
sure that all that needs to be done, and you have the training, you have the systems in place, the processes in place, as you mentioned, educating the workforce so that they know what constitutes harassment within the context of sexual offenses. And so once you do that, however, can we then also say that if I have done all that, that is enough defense? It's up to the court to make that decision. But the point remains that because it happened within the confines of the employment, the employer will be jointly liable to the offender in terms of the victim fighting as to who should be liable. And remember, if there is anybody to respond strongly, it will be, especially when it comes to compensation and all that, when it involves employers, the victim will have the expectation that at least compensation will be adequate and compensation will be possible. If you left to the individual staff and that individual staff is not able to, then the victim will lose out, and therefore now the employer. And it's also twofold, to make sure that the victims are protected, and also to ensure that employers take their duties also seriously.
Well, so a new duty on employers to make staff aware of the new law comes into effect the 26th of October 2024. Um, Employers are vicariously liable if their employees are found guilty of sexual harassment unless they can show that they have taken all reasonable steps to prevent that harassment from happening. It's a community and the law, and it's brought to you by BWF Solicitors, our trusted partners when it comes to the law, located on the fourth floor of Vienna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them Monday to Friday between 9:30 in the morning and 6 p.m. on 0208 493 7340. I say the number again, 0208 493 7340. Those of you in Ghana, they have an office in Ghana. You can get them on 055 5959 or the emergency number 077 127 61884. We have our very own lawyer Charles Asma. His number is what I'm going to put on the screen in a moment. 07947 636037 BWF solicitors want to say thank you very much. We're going to take a break and come back to our discussion. But if you were giving this scenario, how were you going to advise the people in the case I'm going to put forward? And that will be coming up in our quiz. But let me give you a sneak preview into what the question is like. Shall we have that question? And I would want people to think about that. And at the tail end of the program, I will ask you to give me the answer. Jacqueline and Baron Bequin have a 7-year-old son, Jonathan, and the property bought and owned in the sole name of Baron during their marriage. Jacqueline filed for divorce because Baron had impregnated another woman in Ghana when he went on holiday. She asked Baron to leave the house and filed for financial settlement. The matrimonial home is their only asset, although in Baron's sole name. Baron said he would sell the house and ask Jacqueline and their son to live. The question is, what order is the court likely to make? There are three scenarios here. The court will allow Jacqueline and Jonathan to live in the house and postpone the sale until Jonathan turns 21 years old or remarries. The second scenario is the court would evict Jacqueline because Baron owns the property. Or the third one, which is the court will order the sale of the property to Baron and can buy another one. So think through this. I'll bring it up again and ask you what you think the likely order will be when it goes to court. We'll take a break, we'll be back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
You're still live with us on BWTV, and we're bringing you the community and the law by courtesy of BWF Solicitors, our trusted partners when it comes to the law. Our resource person and guest this afternoon is our very own lawyer Charles Asma. Tile Duma, Boba Sari, Wumpini Adam, Abna, Bene Wa Asantewa, Papebi, Ebenose, Seth, Wadu, Sandra Fraser, and all the others that have joined us. We want to say thank you very much for sticking around. And we believe that the topic is going to be of benefit to everybody. Children born abroad have a right of abode. It's quite emphatic. Right of abode, what is that? Children born abroad, what category of children are we looking at? We're doing this courtesy of BWF Solicitors. When it comes to immigration matters, they are on top of everything. When it gets to getting to represent you in court, they are good at that. And also, they can help you with employment issues, litigations of all sorts. And of course, when it comes to property as well, they can advise on that. Contact BWF Solicitors on 0208 493 7340. I say the number again, 0208 493 7340. Emergency number 077 127 61884. Right of abode. Children born abroad. These two things probably will help us unravel that emphatic statement that says children born abroad have a right of abode. Lawyer Charles Asma, let me first of all look at what right of abode is, and then we look at the, as you would put it, or lawyers you put it, I should say, the qualifying children under this situation. Let's unpick them. Right of abode, what is it?
Thank you very much. So we are looking at right of abode. And if we say somebody, okay, so abode is residence. So whether you
Mhm.
are resident in country A, country B, that is your abode. So you travel, you
Mhm.
return to that place. But whether you have right to that abode or not depends on your circumstance. And therefore, in this
Okay.
conversation, we are saying that a right of abode will be the right that children born abroad would have as if they are living in the UK. And therefore, they will be entering the UK as people who have the right to be in the UK permanently. And so
Okay.
rather than, for example, the person waiting to get a passport before entering the country, the person will enter the country on the basis that they have a right to be in that country.
Okay. Now, then children born abroad. Well, I'm looking at this situation where I have a child that's born to me. If we look at the scenario that we'll be using for our quiz, this person went to Ghana, impregnated another person. The person is born outside of the UK. Is that kind of child that we're talking about here, or what?
So the person born to this individual is the person's child, and so to speak, the person will then qualify that at the time of their birth, one of their parent is a British citizen, and therefore they are a child of a British citizen. So, but then the person will have to be able to visit the United or enter the United Kingdom with the passport. But the person doesn't have a passport because it might take some time to even apply for a passport. So, can they enter the UK and obtain that passport? The answer will remain the conversation that we are having now. So, this individual has a child. If it's able to prove
Mhm.
that this is their child, and is able to prove that at the time of the child's birth, they themselves, or he in this case, was a British citizen, then the person will have the right of abode.
Now, they're born to a British citizen, so it doesn't necessarily mean that both parents would have to be British. Does it have to be particularly either the father, or it could be any or either of them?
So the law says that the parent. So if it is a man, so that the father is making the application, but it could also be that the mother is the one who is the parent in this context. And even in an instance where the child is adopted, and that adopted parent is a British citizen, the child will qualify to make an application on that basis.
You have said that whether the child is adopted. So, in this instance, when the adoption takes place, the parent or one of the parents should have been a British national or a British citizen. Is that the most important qualifying criteria?
So for adoption, so of course the person whoever is adopted, sometimes both adults are adopting the child together. So
Mhm.
it doesn't really matter whether both of them or one of the parents, they can still go ahead and apply on that basis. Because the key thing here is this the parent, and what is the immigration status or the citizenship status of this parent. So the adoption certificate could be issued to both parents or could be issued to one of the parents. It doesn't really matter.
Um, okay, now let's look at this scenario again. If the person is settled in the UK, do they have this right of abode conferred on their children who were born outside of the UK?
So for those born outside, it's all to do with the citizenship of the parent in question. Unlike if the child was born in the UK, it will be either settled or citizenship. Those born abroad, it has to be citizenship of the parent.
Okay. Now, We are saying that children abroad, born abroad, have a right of abode, which means that one way or the other, they are British citizens, but it has not been properly documented. So they can obtain their British passport. Could that be obtained outside of the UK? Or to have a British passport, they would have to come to the UK?
So passport can be applied from overseas, but it
Okay.
can be a daunting task compared to if you were to apply from within the UK. And so some children or some parents will allow the children to enter the UK with a view to applying, or I mean, to come in with a right of abode. And once they have entered the UK, they can apply for the passport.
Now, so when the child is coming to the UK, the child that qualifies for the right of abode is coming to the UK. They could come with any passport at all. Is that correct?
When you have a right of abode, what it means is you are a national of that country. It's possible that you have lost your passport or you don't have a passport. So in this case, the child may not have a passport, but they have to then make an application to enter the UK on that basis that they have the right of abode. The question is, do they have to submit a foreign passport, provided that foreign country allows for dual nationality? Because when you are
Okay.
going for example, your biometrics, they will ask to provide an ID. But if you don't have an ID, because you are making a defined application, which is the right of abode, then it's possible the individual or the child can say that I don't have a passport, and would they say they will not go ahead with a fingerprint? They have to then look at the application the child is making. They have to look at all the requirements or in terms of the documentation that are required. Then they will go ahead to apply. Once you have the right of abode certification granted, you enter the UK, and that is your basis of entering the UK.
So how do I get that right of abode certification then?
Right. So you are making application here, just like any other application, just that this one you are applying as someone who has the right to be in the UK because they are a British citizen. On the basis of your parent, you are applying to enter the UK. Once you make the application, you have to show or prove that the relationship is clear. Either
Okay.
the birth certificate or DNA. We know that DNA is not compulsory. However, it's
Yeah.
advisable. Advisable if you have it. If the child is adopted, we cannot talk about DNA. We know the adoption. You can't prove the relationship. It's just the adoption or the certificate. Now you have proven the relationship. The next thing to prove is that the parent has British citizenship when they acquired it, and so on and so forth. You have to put all this together. Again, we are talking about children. What it means is that the person must be under 18 years. So 17, 16, or nearly 18 years, they qualify as children within the law, and so it can still. So if the child or was, let's say, had acquired citizenship, has citizenship of a particular country, having
Hmm.
citizenship of another country, depending on the country we are talking about, does not take away your right to citizenship in Britain, for example. And therefore, if the country allows for dual nationality, then your child can have this nationality also and apply. So you have to show the relationship. You have to show the parent's nationality. We have to. They have to also show that in terms of the age, the child is indeed under 18 years. Where the child is coming to live, and so on and so forth, will be additional requirement. So obviously, you are able to prove that when the child enters the UK, this is where they are going to live. When the child enters the
Hmm.
UK, you are able to look after them. But again, the child who is a British citizen, you don't really have to worry whether they are going to access public fund or not, because public fund will not apply to that particular child. But it suffices to show that you can add the evidence of finance and all that, even though they are not compulsory requirement, you can still add just to prove a point.
So then you would need to prove that you can accommodate the child coming to live in the UK. You should not necessarily a requirement, but you should prove that you have the finances and the wherewithal to cater for that young person. You do not need to worry about public funds because the child qualifies already. Then finally, is it a tick box application where you can straight on provide these pieces of evidence and it will be granted? Or then a caseworker would have to make a determination?
So this will be a matter of tick box. However, the tick box must be measured in the sense that you have to prove every tick box. So if you are taking that the relationship is met, you have to provide the evidence. If you are taking that
Mhm.
the parent is British, you have to show the proof. Whether you are proven by the naturalization certificate of the parent or the British passport of that parent. The date it was acquired is also important. So all these things have to be part of the things that you will need. Once you submit the application, the checklist will be provided for you to make sure that before your biometric or enrollment, you have had all these things provided or submitted, so that the caseworker will then have to make a judgment call. Tick. But is each tick met? And once you've met all the ticks, yes, the next stage will be that they have to make a decision to give you that right of abode entitlement. So it's not a case of the case that the caseworker will have a discretion to give or not to give. So far as you have met the requirement, it is a case that they have to grant.
So then the person arrives in the UK, and what happens? They've come to their country, so they can sit back and forget to apply for a license. Do they have to really regularize their status in another document, or what?
So you are a British national. You are away. You have entered the UK on the basis of your right of abode. You mentioned
Mhm.
earlier on our passport. Would a person have to show passport and so on and so forth? Somebody who doesn't have British passport, is not holding a British passport, but they've entered on the basis of that right of abode, will take steps to apply to be given a British passport, for example. So that at least it
Mhm.
wouldn't be the case that anytime they have to hold that right of abode certificate or entitlement.
Right. So, folks, if you have any issues, any question on this one, I'm giving you the opportunity. You can text us on 07399 208 468. You can also call in on 0208 493 7345, and we'll get you to speak to lawyer Charles Asma if you really want your voice to be heard, as well as you can send a WhatsApp message on the same number as I mentioned earlier on 07399 208 468. As the community and the law, and this afternoon we are looking at that emphatic statement that says that children born abroad have the right of abode, the house, the what, and the whence of that. So we definitely are waiting for your questions. Yes, but lawyer Asman, let me find out from you. If there's a child that's had the right of abode conferred on him, the person comes to the UK and comes to live here. If they turn it, well, let me put it this way: if they do not apply for their passport and they turn 21, or even gone beyond 18, would it be difficult for them to really go for a passport because probably it's delayed, or time would not be of the essence because you can apply a passport at any point in your life? I think you may have been lost on my question. What I mean is, when a person uses the right of abode certification to enter the UK, is there a time limit for them to apply for that passport? Um, Obviously, when you're a child, a parent would apply a passport on your behalf. But when they turn into an adult, would they, having delayed in applying for a passport after using the right of abode to enter the UK, have any impact on their application at all?
Right. I mean, once the person has entered the UK, it's most parents will move to the next step or stage to go through the process before even the
Mhm.
child turns 18. However, if the child turns 18 and they still have not applied for passport, what it means, they still the right of abode is not lost because they haven't done that. But
Okay.
the most important thing is that as soon as the child has entered the UK, because they were going to apply for passport, for example, before they entered, but for the timelines and all those things, they had to use the right of abode route to enter. And so, as soon as they have entered, you move on to the next stage to ensure that the process is complete. It doesn't also mean that if they haven't, but why wouldn't they do? For me, normally when we're educating and learning about these things, you want people to know that delaying is also not a choice.
Okay.
Yeah, delaying is also not a choice. And therefore, as soon as possible, you take steps to deal with it.
Right. Okay. Now let's look at another scenario where um, a child born to a British national, but the child was born prior to the person having their British citizenship conferred on them. Such children, would they qualify under this right of abode situation?
So the rules say that at the time of the child's birth, one of the parent. So if
Should
at the
be.
time of the child's birth, this particular parent was had not become a British citizen, then the child cannot say they have right of abode per se.
So what if I kind of register to have this child under me, and then if the person like before 12 years or thereabout goes through that, can they apply for such or even British citizenship outside of the UK, or they may have to come to the UK to live with the parents before they can
So,
do that?
well, in this case, if you can prove that at the time the child was born, the parent was already a British citizen, the parent will bring the child to settle with him or her in the UK. And once the
Okay.
child has entered the UK, the next stage will be to register the child to become a British citizen, after which they will, if they wish, apply for British passport.
Well, viewers, my question was deliberate, just to emphasize the point that at the time of doing such an application, asking for the right of both certification, you would have to be a British national, and when the child was born, one of the parents should have been a British national. If your child was born prior to you having your British nationality conferred on you, that's a different case, as lawyer has just explained. Well, the lines are active now: 0208 493 7345, or you can send a voice note or text message to text and WhatsApp number 07399 208468. 07399 208468. It's a community on the law. We're taking another break to say thank you to BWF solicitors. And when we come back, we're taking your questions, your comments. You can put them in the comment section down below on your Facebook page and YouTube page. We are at BWF solicitors, both on Facebook and YouTube. BWF solicitors, both on Facebook and YouTube, and also at BWTV both on Facebook and YouTube. We'll be back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
BWF Solicitors, thank you very much. You have been gracious to us and been helping us all throughout. Over 33 years of experience, and I believe that if you would want to find an organization that would deal with your legal matters, especially when it comes to immigration issues here in the UK, you're looking no further than BWF Solicitors, located on the 4th floor of the Anna House, which is 214 to 218 Tottenham High Road, Seven Sisters. 0208 493 7340 is their telephone number. We're going to your comments and your questions, and we have Idrisu's one says, why is it that the Home Office will give companies license to employ international prospective employees and then cancel the license, and it's employees who suffer? Why do they do that?
Right. Yeah, it's laughable why they do that, and that is where the laughter came in. But it's unfortunate that they do that to them. But the question is for the employers who do not do the right thing. And the question is, why don't the employers do the right thing so that Home Office will take their license away from them? And the employees who suffer, why is it that the employees also do not go through to make sure that these employers are legitimate before we engage them? So you can see it's a very complex maze that we are trying to navigate. And therefore, you cannot really blame anybody. But the most important thing is got to be careful dealing with employers, because some employers may not necessarily have the job, but they will give you expectation that, after all, it's all paperwork. And once they have given you all the paperwork, the practicality is that once you've arrived or entered the UK, the question is whether the job is available for you. Some of the employers too, they don't do the right thing, and they don't meet their compliance obligations, and so their license is taken away. Unfortunately, because the employee's certificate is linked to the license, once the license is not there, they cannot keep the certificate, and that is why they end up losing. But the good thing about the process is that once the employer has lost the license, the employee will be given 60 days to find another employer. Unfortunately, that may not be enough time, but at least the duty is for the home office to give you time to look for a new employer. So what we have to do is all be vigilant and ensure that we don't put ourselves at risk of the employer losing the license and we finding ourselves wanting.
Well, you can bring in your questions, your concerns, put them in the comment section below, or send it to our text and WhatsApp number. The number is 07399 Or you can call in on 0208 493 7345. Now, lawyer, going on to further questions, there's this person who wants to apply for the renewal of the child's passport outside of the UK. The marriage or the relationship with the child's father is kind of strained. If they are renewing the passport, do they need the father's consent to do that?
So with passports, you don't really need consent. It's the registration process. If the child, but this child is already British citizen, I suppose they had a passport and the passport is expired whilst they are away.
Mhm.
And well, you don't need consent. So one of the parent that is applying on their behalf will be, but they will ask for the details of the other parent, name, date of birth, nationality of the other parent. So not necessarily consent for both or for any of them.
And in this situation, can this one parent bring the child to the UK and do the application here, even though the passport is expired?
So the child's
The child
passport,
is British, coming back to their country. The passport
yes.
is expired whilst they are away. Would it be detrimental for them to travel at that time?
So it's just like anybody who is traveling to their country and their passport is expired, they will get um, certificate to travel from the
Mhm.
embassy, from the embassy,
Oh,
so that when they enter the UK or enter the country, they can renew the passport.
okay. All right. If you have any question, you can drop them on the or in the comment section. Sorry, on your Facebook page and YouTube page. Please, can I change my picture that I uploaded when I first signed up my e-visa? Um, I think it will go on to ask that when you have signed your e-visa, can you go back to edit the information you put on there?
Usually, you don't have the opportunity to change, but for me, I wouldn't really be too worried because yes, the picture may not be the type of the picture I wanted, but the most important thing is your image is there and you have your e-visa available. So provide, I mean, the fact that most people will not be watching that picture to say why is this like this or that, I wouldn't be worried.
Although sometimes you look at some picture you've used for some applications and some documentation, and you're like, I wish I didn't take this. I want to change it. If you're not comfortable, can't you do that?
Well, at the moment, there's no chance to edit. I haven't checked. I may have to check to see if there is that. But the key thing is, this is not even a card that somebody may be looking or having access to see, oh, why is your picture like this? But it's online. The immigration officers will be the one to see, employers will be the one to see, and people that you need something from them are the ones to see. Your friends and family members may not even see the picture online because they have no business seeing the picture, and therefore I wouldn't waste lose sleep. But if this person feels that they cannot live without the picture changing, they may have to call there's I think there's I haven't checked whether there's a telephone line, but they can look up e-visa contact helpline and call a line to say that I want my picture changed, and they will be able to assist. But for now, there's no option to edit certain things.
Well, for emphasis, I would want to reiterate that the Home Office has told everybody, those who would have to have an e-visa account, that your biometric card will be expiring on the 31st of December 2024. And they have asked everybody that falls into that category to apply for an e-visa account, so information will be transferred on there. Now, beyond the 31st of December 2024, the biometric cards will not be functional anymore, and all your information will be online. So the advice is get your e-visa account. Now, if you have challenges doing that, the BWF solicitors has offered that you could call them and they can guide you through opening an e-visa account and doing it right. So you can call them 0208 493 7340. Now remember, BWF Solicitors has done so much for community members, and people are appreciative of that. We read one earlier on in the program, and we have those reviews and commendations coming in. So trust BWF solicitors when it comes to all immigration matters and other matters of legal concerns. Children born abroad, you have a right of abode in the UK. Lawyer Charles Asma has explained that it's time for us to pick up your questions and concerns, put them before them. It could be about the topic we have discussed, or it could be any other legal issue that you have a concern about. Pa says, can skilled worker do fee waiver before they apply for indefinite leave to remain, lawyer?
Skilled workers, okay, so let's put this into context. Fee waiver is for human rights application.
Right.
Skilled worker is not a human rights application, and therefore you cannot apply using fee waiver.
Okay.
Indefinite leave to remain cannot also attract fee waiver unless specific criteria apply. For example, domestic violence or a widower, or on that basis. So if you are going to apply for indefinite leave to remain, you pay the fee that you need to pay.
Okay. So yeah, I think last week we did the justice to this particular question, and we were saying that those who try to use fee waiver applications to kind of buy time may be falling foul of a law and could be interpreted as misrepresentation. So those who do that should beware, because if you apply for a fee waiver, then it means that you have the intention of making an application under the human rights conundrum. If you do not intend to make that application and you apply for a fee waiver only to buy time, then it means you may be falling foul of the law. You can go back on our Facebook and YouTube page, the Community and the Law program that we did last week. The full video is there. You can watch back, but that is the essence. Don't ever think of applying for a fee waiver when you don't intend to make a human rights application. I think I've summarized it right, haven't I?
Yes, you have.
Okay. Well, we still have time, so you can come in with your question and concerns. The number is 0208 493 7345. Patrick says, in making applications for healthcare switch visas, do you have to pay immigration surcharge, lawyer?
With the healthcare, so it's I don't know whether it's separate or not, whether it's not, but it's combined. So what they have done is you pay a specific application fee to the Home Office, and that is it. So there's no separate fee for visa, there's no separate fee for health and care. And I think the reason is that the person is coming to work in the care sector, and so they don't have to pay for that. It's also possible that they have combined the fee, and therefore you just pay once. But to answer Patrick, you don't have to pay immigration health surcharge separately.
Well, thank you very much, Patrick, for bringing it up. Yes, you also have the opportunity to drop yours in the comment section. Nanetia Hene, after December, how can an applicant be able to submit evidence of their partner or child immigration status during application or submission of documents relevant child or partner who is not British and sponsoring an applicant? How can evidence of their immigration status be submitted after December? I think he's trying to make reference to the e-visa account.
You just say yes. Okay, I mean, it doesn't change anything. What is not going to be available is the card, but everything is available online. So you open the online account and print it and attach.
Okay. So then, yes, nothing really changes. You just have a different way of showing that you have those status and situations. Yes, keep them coming through. You have Charles says, what would be the case if lawyers like yourself are making applications for clients, the email to use for decisions, if everything has to link to the visa e-visa account? Secondly, how would passengers evidence their e-visa status to third world countries, using Ghana as an example?
Okay, I'll start from the second question. The first question, it's not quite clear, but I'll come to that though. So the second one is at the moment, all third world countries are aware that UK uses cards, what we call biometric residence permit or biometric residence card. So they are aware,
Mhm.
they've been told and educated about it. With the e-visa regime, they have been told as well. And they know that from 1st of January 2025, all the cards that people were showing them would have expired. And if they are expired, it doesn't mean that they don't have status. It means the status is online. And therefore, they will have a way to check themselves whether the status is there so that when they enter the UK, they are not entering illegally before they allow them to pass. The first question.
I Lawyer, before you go on, the Charles mentioned that third world countries, there are some um, immigration situations in the departing country where the airlines will say, well, we are not aware, or I can't go online to check. So if your card has expired, I'm not allowing you to travel. People will have these challenges. I guess that's the concern Charles is expressing.
Yes, if I'm the one, I will print a copy of my e-visa which shows my name, my details, including my picture, and also my immigration status. I will add it to
Mhm.
my passport. I also add my visa letter, the original visa letter that shows that my visa will expire, for example, in 2026. I will add it to my
So,
passport. And if I'm able to show and also add the broadcast that the government is saying that everybody must do e-visa. Otherwise, after this date, there's no card valid. I will add that I'll print it and keep it as well. Even though they are not necessary, just to prove a point and also to be comfortable that with this,
mhm.
there's no way an airline will not allow me to pass, or the immigration officer in a third world country will not be convinced that I have legitimate reason or stay in the UK. But the education is still going on, the sensitization is on, and therefore there will be teaching problems. But I do advise or suggest to people that if you are unsure, have all these documents in your bag so that you show them 1, 2, 3, 4, 5. There's no way they will say you don't have leave to remain in the UK.
Yeah. The first part of Charles's question, what would be the case if lawyers like yourself are making applications for clients to the email to use for decisions, more or less may be the lawyer's email.
Mm.
Um, if everything has to link to the e-visa account, what email are we looking at now?
Well, e-visa, you don't link email per se because when you are creating your e-visa account, you use your own email, so it comes to you. Even if somebody is helping you to create an e-visa account, it will still be your email account. Lawyers don't
Okay.
create. So e-visa account is not an application. It's just transfer of your um, immigration from one point to another. I call it the box. The box of your status is the card. And they are saying that the box is no longer going to be used. So put it into another box, which is online. So that is that process. But with application, let's say 1st of January, somebody is applying will apply. But once the application, I think I get the person's point. Where doesn't then we can ask the question after 31st December 2024, are we going to stop making applications? Because you're not going to give me a card. So what's the point? You still have to,
Mm.
because you need your immigration status to show online. So when we will apply, we still have to communicate with the Secretary of State or the Home Office or the caseworker. So we use our email or whatever email address. If you are doing it yourself or your friend is helping you, use whatever email address so that you know up to the point where your decision comes. Once the decision comes, you have still your decision letter to keep. But then, instead of getting a card, everything will be online. And at that point, you don't have to create e-visa account. At that point, everything would have been automatic, just like the EU visa holders. Everything will be automatic online, and you don't have to go through a second stage of creating an account.
Well, we still have time to pick a few more concerns and questions, so keep them coming through. Ankara says, good afternoon, Lawyer Charles. My entry clearance visa will expire next week, 16th October 2024. Can I enter on the 12th?
I don't know what the entry clearance this person is talking about is, whether it's visitor's visa or student or skilled worker or 2.5. I don't know what it is. So if Julius can come back to say it is this, then I'll be able to advise.
Okay, now let's look at it, maybe to help him once he gets ready to come with further. If it was a visitor's visa, for
If it was
instance,
if it was a
and
visitor, okay.
the deadline is 4 days away, he enters 4 days away from the time that it would have expired.
So if it's a visitor's visa, the question is, you were given visitor's visa for 6 months and you didn't enter the UK for 5 months, 26 days.
Mhm.
That doesn't mean you've changed your mind to visit. And if you haven't visited till the last 4 days, does it also mean that whatever you intended to come to the UK for is no longer necessary?
Mhm.
If it is still necessary, can you do whatever you are coming to do in 4 days and return? And if all these questions are not answered, the presumption will be that you may enter the UK and after 4 days you'll be illegal, and that will affect your status. So they won't let you enter in the first place.
So, for instance, if let me look at this scenario. Somebody was to have entered or visited the UK for an event, and then also on the supporting letter to enter for that event said that I would be visiting a relative afterwards and stay for a few weeks before I go back. Uh, for some reason, the person didn't enter for the event that was one of the reasons why the visa was given. Before the visa expired, can they come in for the second reason?
Are we still talking about the 4 days left?
Well, it could be a month more, it could be a few days more. Can the person do that?
All right. So when they first applied, they said they are coming to do a particular, or they come for a particular purpose, and
Hmm.
they were given 6 months. 6 months is multiple entry, so that you can return, go back, and come back in. But when you
Hmm.
are coming back in, the question will be, what is the purpose of the second entry? The fact that you
Hmm.
didn't make an application for another visa doesn't mean that the immigration officer cannot ask you a question.
Okay.
And the answer you provide will determine whether they should allow you entry or not. If they don't allow you entry, they will say that the purpose for re-entry is not convincing. And so it depends on how you are going to approach it. You can see that with visitors visa, it's a whole complex conversation. And therefore,
Hmm.
you will not succeed if you have only 4 days left. But what we are saying is that if you have, let's say, you were given 6 months, you've entered the second month, you returned, you are coming back the third month or the fourth month, you still have 2 months left. It's likely they will allow you if you have good reason why you are entering again. Let's say you first came for a program, and this program is ongoing, it's run almost every week, and you are coming for another program for the purpose of enriching yourself or whatever it is, and you don't have to go for another visa. That's good reason for them to allow you entry. But 4 days left, 4 days left, it will be difficult to convince any caseworker, or I mean any immigration officer or border officer that if you are allowed entry, you are not going to be an overstayer after 4 days.
Let me ask this as well. In addition to that, I think the person's question has brought up so many scenarios. Now, if, for instance, I enter within the period, not 4 days left, but well within the period of the 6 months, when I enter, how long can I stay in the UK for?
When you are applying for entry clearance, they ask you, how
Mm,
long are you going to stay in the UK for? And you would have told them how long. So let's say you told them 2 weeks.
okay,
They expect you to return after 2 weeks,
okay.
unless something unexpected has happened and that you cannot travel back. For example, you came to visit your family and the family member is unwell. Commonsensically, you will not be able to leave them behind. And if that has led to you overstaying, I mean, staying on, not overstayed, but staying on longer than you said you will, that's good reason why you stayed longer than you thought. But you come in to attend a program. The program has ended within the 2 weeks, and you are staying on for whatever reason. That may not be convincing enough. Nobody will know, because when you are going back, they will not ask you what else did you do. But in future, when you are coming back, they are likely to pick it up to say that when you first applied, you said you are going to spend 2 weeks. You ended up spending 1 month or 6 weeks or 8 weeks.
Mm,
What shows that we can trust you that this time you will spend the period you claim you will. And that is the caseworker's discretion to say that on that basis you should be granted or you should not be granted. But those are conversations, or those are things the caseworkers will be dealing with. But
okay.
for us as members of the community, the advice or the opinion within the law is that once you enter the UK for 2 weeks, to spend 2 weeks, please, after 2 weeks, go back and come back in. For example,
Okay.
there was a visitor visa application I put in for a client. The client entered for graduation and left and was coming again, this time to visit the family. So the explanation was that this person entered for this purpose and returned within the time they said they will. The person has proven that they are genuine visitor or credible visitor, and therefore this time they are coming to visit family for 4 weeks. They will go back. It's possible, and it's on the balance of probabilities. It is can be confirmed that it's true that when they come in, they will return. And so the person should be seen as a genuine visitor for the second application. So you see, we are making a second application and we are able to argue on the basis of the history they have, which is positive. But if you have a negative history, the same way when you are making the second application, you have to explain why it happened like that. You don't just leave it. So if you stayed more than 2 weeks, or you stayed more than you said you would stay, can they find out? Of course they can, because they have all your record. When you entered, when you
Mhm.
left, and the application you submitted itself, they know. So they can pick it up and question you on that. So when you are making a second application, you can explain that my first application, I was granted 6 months. I entered. The original plan was to spend 2 weeks. Unfortunately, I fell unwell and I couldn't travel, or my family member I visited was unwell, and I had to ensure that they were healed or they were okay before I could leave. And as a result, I stayed on for 2 more weeks or 1 more month, which made my stay in the UK 6 or 7 or 8 weeks or 10 weeks instead of the original 2 weeks I intended. this is the reason and not that I deliberately stayed on. In this case, the caseworker will put it into context in deciding whether to grant the second visa application for visitor's visa or not.
Well, time and tide, they say, waits for no man. So we will be taking a break now. But when we come back, we'll be looking at our quiz situation. Remember, I gave you that scenario earlier on. Let's take a quick look at that and take a break. When we come back, we pick your answers on that. The quiz, the measure order said that the courts have found a way of postponing the division of a later date to a later date, sorry, where there is not enough to go round. Measure order allows for a delay to the sale of property for the final period of time or until a specified event occurs in relation to the children of the family, enabling one party and children to continue living there. Then I asked you a question about this couple that one had the situation of impregnating another woman and the wife filed for divorce. Jacqueline and Baron Bequin have a 7-year-old son, Jonathan, and a property bought and owned in the sole name of Baron during their marriage. Jacqueline filed for divorce because Baron had impregnated another woman in Ghana when he went on holiday. She asked Baron to leave the house and filed for financial settlement. The matrimonial home is their only asset, although in Baron's sole name. Baron said he would sell the house and asked Jacqueline and their son to leave. Look at that scenario and situation again. He said he was going to sell the house, so he asked the wife or the former wife and their son to live. What order is the court likely to make? Is the court going to allow Jacqueline and Jonathan to live in the house and postpone the sale until Jonathan turns 21 or remarries? Is the court going to evict Jacqueline because Baron owns the property? Is the court going to order the sale of the property so Baron can buy another one? Tell me which one is your answer after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Welcome back. Let's see what answers you have to Jacqueline and Baron's situation with their son Jonathan. What is the likely order the court will give? Kojo 24 says it's number one. The court will allow Jacqueline and Jonathan to live in the house and postpone the sale until their son is 21 years, or I guess Jacqueline remarries. Let's see who else has come up with another answer. Gerald Akbat says number one. Okay, who else? Let's see what you have. Emilia Alote, number one. Then who else do we have here? Let me check. James Bonsu, Jimmy says number three. Okay. Number three says the court will order the sale of the property so Byron can buy another one. Mary Kujo says number one. Okay, now I think I've got so many people thinking of number one being the answer. Michael Darcy says number one as well. Who else? Who else do we have here? Patricia J. Patricia J saying it's number three. The court will order the sale of the property. Okay. Pat, thank you for that. Next, Robert Danso. Bobby says number three. Right. Okay. Let's move on to Jennifer Dia. Jennifer Dia says number one. Kojo 24, I've seen yours. Kwabene Yisi says number one. Tilly says number one as well. Okay, so let me go to lawyer and see what answer he would give us the correct one. Most people are saying is number one. Are they correct?
So we are going to mark our script, and based on the pointers, it will be obvious which one is. So under measure order, we want to identify the constraints. The court will then consider certain things. One, children involved. Two, how many assets are involved. Once the asset is identified to be limited, for example, only one, and it's difficult to share or distribute without somebody suffering, especially children, then the court will delay or hesitate to make an order to sell. So in our scenario, we are told that there is a child involved who is 7 years. We are also told that the property is just one, or the asset is limited, one. What it means is that, and we also told that the family live there. We are told that somebody wants the property sold so that they have clean break and they move on with their lives. We are not worried about the adult moving on, but the child. And so the court will consider, what are we looking at? Only one asset. If we sell it, will it affect the child? Possibly, yes. And on a balance, it's more likely that the child will suffer. So even if we don't care about the woman, we care about the child. But again, if we sell it, where would the woman live? And so the court will consider the woman, will consider the child, but more so the child. And once the court has considered, the court will say that, no, let's wait for the child to attain independent age, completed secondary school, or tertiary education, in this case, university or polytechnic or whatever, whichever is later. And by that time, the child would have been 20, 21-ish, depending on the frequency of their education or if they are going through the education process smoothly. And so the most likely answer will be that the court will delay the process until the child is of age 1.
So the answer, as lawyer said, is number one. From the explanation, I can say, as lawyer has explained, that there is not enough to dispute during divorce. Generally, the sale is postponed, or realization of the charge is deferred until death, remarriage, or remarriage of the party in occupation. The younger child of the family, occupation, the youngest child of the family, I mean, attaining a certain age or seeing full-time secondary or tertiary education, whichever is the later or further order of the court. So those of you who are interested, you can go online and read the Mersha versus Mersha 1980 case. So those who said number one, you're correct. And with that, I throw it back to lawyer for us to have a quick summary of what we have discussed this afternoon: the right of abode for children born abroad.
Thank you very much. Viewers and listeners, today we have looked at children born abroad having right of abode in the UK. This happens when the child is British because at the date of their birth, the parent, be it one parent or both parent, one of the parent is a British citizen. The child is supposed to join the parent in the UK. However, time constraint will mean that to wait for them to obtain their passport to enter the UK can create problems. And so they apply for right of abode before they enter the UK. The parent must show that this is their child, or the child must show that this is the parent. And so the relationship should be clear. Birth certificate or DNA. DNA is not compulsory. It's only advisory. The parent must also show that they have British citizenship and that it was obtained or attained, granted to them before the child was born. Once these things are in place, the next stage is to put in the application, adding all the necessary documentation, and it is the caseworker's job to consider the application to grant the child right of abode document to enter the UK. This is what we have covered today. As I always do, have a pleasant weekend. Anytime you need help, please knock on our doors. And please remember, we are in October, next month is November, and December 31st is the last day for e-visa process. So if you haven't still done it, please make sure you spend about half an hour to do it. If you need help, please come to us. We will assist you. Shalom.
Well, thank you very much, lawyer. And this kind gesture is what has been appreciated by a family that sent in their review. Now, you would also have to enjoy the welcome and the expertise of BWF solicitors. So I'm asking and inviting you to visit them on the fourth floor of the Inn House, 214 to 218 Tottenham High Road 7, Sisters, North London. You can call them Monday to Friday between 9:30 in the morning and 6 p.m. 0208 493 7340, or the emergency number 077 127 61884. Viewers, let's say thank you once again to our very own lawyer Charles Asma for his time, for the share of knowledge, and the benevolent invitation to really come over to them for them to help us. This afternoon, we considered children born abroad who have a right of abode in the UK. We have found out how, and we found out what we need to do so they can take advantage of that situation that has been conferred on them by virtue of the fact that one of their parents at the time of their birth was a British citizen. And your questions have also been rightfully answered. If any other question, as I keep saying, please draw near and close to BWF solicitors. Call them 0208 493 7340. You can also talk to lawyer Charles Asma. I always keep his number on the screen for you: 07947 636037, 07947 37, and he will be so kind enough to help you with that. So on behalf of everybody at BWF Solicitors, from the senior partner to everybody there, those are the front desk, our caseworkers, our lawyers and partners, and to our technical team, I'm talking about Sheila Ankra for the admin and Padma Dodo for the aesthetics, and to my studio producer, Professor Ade, for being so good and magnanimous when it comes to the show coming your way live every Saturday. My name is Oreku Frimpon. Have a good evening. I'll meet you again same time next week.